is an allegation that Advocate Chauke sought improperly to get Advocate Mulotshwa to sign the indictment?
There isn't.
Thank you very much. Now, can I ask you about 3.1.1.2? It says that presumably you recommended to the then acting National Director of Public Prosecution, Advocate Nomgcobo Jiba, the application for issuing a racketeering authorization in terms of Section 2.4 of the Poker Act, whereas there was no evidence justifying the institution of racketeering charges against the accused. Now, the recommendation that is referenced there, is it the document we went through repeatedly, which is PP'd by Advocate Chauke? I just want to get the...
Please repeat your question, Council.
Yes, maybe what is better is that I must just refer to the document
I think
itself.
that will be helpful.
Yes. My Leonard Jr. will find it now. The question really is this. You had a discussion with Madam Ramachakha about whether or not Advocate Chauke's recommendation was PP'd or signed by him. I just want to know if the charge is referring to that particular document.
That is certainly one of the documents it will be referring to. I'm not sure if it's the only one.
All right, let me find the specific document right now, because you might help us on that. But the second question I have, I'll come back to this as soon as we find it.
I think I should try to find it as well. Chairperson, if I can get some assistance so that we have the documents ready through you, Chairperson. I'm not sure where these
Indeed.
documents are.
Yes, Madam. Advocate Hali, where's your junior? She doesn't appear to be here.
They're trying to find their documents.
She's trying to find the document.
Yes.
I will take that document because I think that's
No, my junior was quick on the mark. It's LO00780.
M
LO
LO
00780.
80.
Yes.
Is that an internal memo from Advocate Nokumashilu to Advocate Jiba?
Yes, Madam Chair.
Yes, thank you.
Yes. Dated the 15th of August, 2012. Now, the reason I ask...
May we wait for Advocate Batohi? Do you have it?
I do have it now.
You have it,
Yes.
Madam.
Now, the reason I ask Advocate Batohi is that it is the only document I could find that uses the word, I have perused the documents and recommend the application. And when you look at what is recommended, is at 1.3 are the draft authorizations for Section 2.1E and 2.1F of POCA. Is that what you are referring to in 3.1.1.2?
This is definitely what we are referring to.
All right, that's fine. We can note that that's the document you are referring to.
I didn't say it's the only document, but it
Well,
is a document that
show
we're
us
referring to.
any other document.
I'm
that-
not sure if it's shown to me, then I might be able to comment on it.
Well, in your evidence in chief, you did not make reference to any other document. In our own search, we did not find any other document where there is a recommendation for the signature of the racketeering authorization, other than that document that involves Advocate Chauke?
I think there's another document that's prepared in his name, but is not signed by him.
Yes, exactly. That is the only document that he signed. I know what I'm asking you.
Mhm.
So I come back to my question. This is the only document we could find that is signed by Advocate Chauke.
Relating to the racketeering authorization.
Well, that is obvious, Advocate Batohi, please, because I am talking about 3.1.1.2, which is about the racketeering authorization.
No, with all due respect, I don't want to take, things may not be that obvious. So I want to make sure when I answer, we're
All
clear
right,
about what
I
I'm answering.
apologize. Yes, the answer is yes.
So in this case, it does relate to the authorizations for racketeering. That's correct.
Yes. Well, let's make this clear because I Advocate Chauke, which reference authorization under Section 2, subsection 4 of POCA. Is that correct?
That's my recollection.
Yes. Thank you very much. Now, with staying on 3.1.1.2, that charge has nothing to do with the predicate offenses independently. I understand that predicate offenses are part of POCA, but it has nothing to do with the separate charges. It's limited only to Section 2.4. Is that correct?
That's correct.
Yes, thank you. Now, if we could also analyze 3.1.1.3.
Mhm.
It says Mr. Chauke sought to defend the institution of the aforementioned racketeering charges in the review proceedings brought by Major General Boysen to have the said racketeering charges set aside, and that he finalized the answering affidavit of the then acting National Director of Public Prosecutions, Advocate Nomgcobo Jiba, in the Boysen review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, is it the case of the NPA that when it says Mr. Chauke defended those proceedings, it is referring to the role he played in the preparation of the answering affidavit of Advocate Jiba?
It is definitely that.
Yes. Yes, but there is nothing else. It is only that.
I'll have to think about the evidence carefully. I've laid a lot of evidence, and I don't want to concede that it's only this if I haven't really carefully considered what the evidence is. So I need to think about this.
You know, Advocate Batohi, you have spoken in this inquiry, I think, for 12 days. For you to say you still have to think carefully about the evidence really sends a negative signal.
That's your opinion, Advocate.
But I presume you have thought about the evidence you've given for the last 12 days.
I certainly, it's been something that has been consumed me for the past 12 days, but there's a lot of evidence. So I need to be careful when I say it's the only evidence, because there's a line, so I need to think about this. I don't want to concede, and then there's something else. So I should be allowed to think about this carefully.
I'm not asking you not to think about it, but I am putting to you that before you gave the evidence, you should have thought about it. You cannot be asking to think about it during cross-examination.
That's your view. I'm going to think about it anyway before I answer your question. So this is definitely one of the aspects of his defending the institution of racketeering. I'm trying to think about whether there's anything more in this respect.
Can I also assist you? The charge itself limits the factual basis to the finalization of the answering affidavit. It does not include any other thing.
If I may on that point say that the chapeau to these charges, if we want to call them charges, for want of a better word, states at 3.1, his direct or indirect conduct should be the direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to the matters related to the following allegations. And my point is that in as much as these attempt to set out or do set out conduct of Advocate Chauke in this context, it is not limited to this.
Well, this is what I'm debating with you, Advocate Batohi. What is the indirect conduct that is referenced?
So I need to think about all the evidence that I've provided thus far.
But I'm asking you, I'm putting to you that the charge is 3.1.1.3. You are saying in answer to me, no, look at indirect evidence. And I'm asking you, what is the indirect evidence?
With all due respect, I didn't say look at indirect evidence. What I said is that I was reading out the chapeau, and I said it states including but not limited to matters related to the following allegations. My point being not about indirect conduct, but about the fact that the allegations are not limited to what is set out in 3.1.1.1 until 3.1.1.5. That
Now,
was the
what
point.
are the other allegations that are not included? What we cannot have.
For example, the allegations relating to the signing of the Advocate Chauke's request for Advocate Malochwa to sign
No.
the indictment,
No,
that should
please.
have been included here.
Please, Advocate Batohi, we are at 3.1.1.3. At the stage at which Major General Boyson is in court, the NDPP is filing an answering affidavit. The charge tells us that its scope is the finalization of the answering affidavit. You are resisting my submission to you that that scope is limited. You're saying it's unlimited. I'm asking you, what are the other facts that support the defense of that review application?
I don't know for now if there are any other facts.
Thank you very much. Can we then go to a second aspect of that charge? You know, the last line, which starts with of racketeering charges against the accused.
I beg your pardon, Counsel, to interpose. The question that you asked Advocate Batohi in relation to the specific aspect, that is the scope of 3.1.3. Might we look at page 66 of the affidavit? It might help us. Page 66 of the record that contains your affidavit, paragraph 156. You have it, Advocate Batohi?
In a moment, Chairperson. Yes, I'm there.
Paragraph 156 of your affidavit gives us the essence of the allegations against Advocate Chauke. And for the purpose of the last question by Counsel, we may look at 156.4. You remember that?
I do,
You
Chairperson.
see that?
Mhm.
And by mere looking at paragraph 1556, giving us the essence of those allegations against him, that is Advocate Chauke, the essence is there. And it includes 1564 to the extent that he settled the affidavit of Advocate Jiba. And there appears to be nothing more in that paragraph 156 as regards the question that is put to you. Am I correct?
This is the essence of the allegations, indeed, Chairperson, which is summarized in this paragraph.
I am specifically referring to 156.4 as regards the question that is put to you regarding the conduct of the alleged conduct of Advocate Chauke in settling the answering affidavit of Advocate Jiba. And I'm asking, is it correct that there is nothing more to this paragraph 156.4 in this affidavit? Your affidavit?
Chairperson, I'm not sure if there's nothing more because this was, as I said, summarizing the essence of the charges. I don't know if this is dealt with anywhere else in the affidavit.
This is your affidavit, counsel. With the greatest of respect to you, you should be able to help us because it is your testimony. You should know this affidavit better than us. It is your affidavit under oath. Otherwise, we are going to have to adjourn again and read this affidavit so that we ascertain whether there is any other part in your affidavit that makes reference to the further conduct of Advocate Chauke that is impugned.
I'm trying to go through the affidavit quickly, Chairperson, to the other sections and look at whether it was covered, because I know when we were drafting it, we dealt with the allegations and then we summarized the essence. So I suspect that it would be covered somewhere else as well.
I request the lady next to you and the junior counsel over there, if there is anything else that you might have picked that may be of help to Advocate Batohi, don't hesitate to bring it to her attention.
Yes, if they could check in the electronic version, it will be easier perhaps.
You may quickly, counsel, look at the electronic version.
I'm advised 146 might be applicable. 180. 180.
I think 146 is just a replica of what is stated in 156, the essence
Okay,
of the two.
146.
146 reads, in response,
Mhm.
Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him.
Mhm.
And that reiterates what appears as an essence at paragraph 1564.
That's correct, Chairperson. I'm checking 180 as well. Mm. 180.8, I think, Chairperson. Those are the only places. Those are the only three places. Okay. Those are the only other places that they can pick up electronically, Chairperson. And so we should accept that those are the only places where this is mentioned.
One
0.8.1.
8, page 76 of your affidavit. The heading there read, there is prima facie evidence that Advocate Chauke was complicit in the fraud and perjury charges leveled against him. And 188.1 reads, Chauke deposed to a confirmatory affidavit in the GCB case, where he confirmed that he finalized Advocate Jiba's answering affidavit before Groven's judgment gave rise to the fraud and perjury charges against Advocate Jiba. I suppose the point that you are referring to is the first line of 180.8.1. That again, and not necessarily so, that he deposed to a confirmatory affidavit, supposedly following the answering affidavit that you relied upon earlier. Is it a different matter?
No, it's the same matter, Chairperson.
Thank you.
Thank you, Madam Chair. I think could we just come back to this topic, because I'm just not sure if there is any difference. Let's start with 3.1.1.3, which is the charge. Okay. Now the charge says you sought to defend the institution of the aforementioned racketeering charges in the review proceedings brought by Major General Boysen to have the said racketeering charges set aside, and that you finalized the answering affidavit of the then acting National Director, Advocate Nomgcobo Jiba, in the Boysen review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of the racketeering charges against the accused. Now, my question to you was, my reading of this charge is that the scope of that charge is limited to the role Mr. Chauke played in the preparation of the answering affidavit of Advocate Jiba. Your answer was no, it may be broader than that. That's where the discussion started. Now, the chair then intervened to say perhaps your affidavit can shed more light. Now, let's look at each of the paragraphs you've now cited, starting with 146. Now, paragraph 146 reads, in response, Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him. Would you accept that that is the same as 3.1.1.3, it does not add any additional facts.
That's correct.
Yes. Now let's go to paragraph 156. Now, paragraph 156, the relevant part, as pointed out by the chair, is 156.4, which says he settled the affidavit of Jiba, and the allegations contained in Jiba's affidavit were found to be false, and as such, he had made himself party to those false allegations. But the conduct is still the same. It's the role he played in the finalization of the answering affidavit. Is that correct?
That's correct.
And then the last one is paragraph 180.8.1, which reads, Chauke deposed to a confirmatory, should be a confirmatory affidavit, in the GCB case where he confirmed that he finalized Advocate Jiba's answering affidavit before Governor J. Govern's judgment gave rise to the fraud and perjury charges against Advocate Jiba. Again, would you accept that the conduct is still the same? It's the role of Mr. Chauke in the finalization of the affidavit by Advocate Jiba.
That's correct.
Yes. We can then come back to where I started. There is no other case that Advocate Chauke is other than the role that he played in the finalization of the answering affidavit of Advocate Jiba. Is that not correct?
Yes, let me just say that there's different actions that Advocate Chauke took in this process. For example, liaising with the team and Advocate Hodes, but it's all in relation to the finalization of this affidavit.
Yes, but I've never asked you about those sub-steps. I asked you that the conduct you are worried about is the role he played in the finalization of the answering affidavit. Obviously, he did many things, including signing a confirmatory affidavit. But what I want us to agree about is that that charge, the scope of it, is limited to the role he played in the preparation of the answering affidavit.
I'm trying to answer this set in a way that conveys not precisely, because it's difficult to be precise, but conveys the full scope as has been put to me of his conduct in defending the racketeering charges. Certainly the finalization of the answering affidavit is an important aspect of that conduct, and is the one that is referred to in this subparagraph or 3.1.1.3. And I hear Advocate Gaitobi saying that he doesn't want the steps, but it relates to the scope. That's the conduct broadly. And so to that extent, I can agree that it relates to that conduct.
Yes, now, thank you. Now, the charge is even more limited because it is about the finalization of the answering affidavit. Now, you have other things you wish to add to the charge, but they're not in the charge.
So as I mentioned earlier, I have testified about what I know and what I've experienced and what I've found in this process. And I'm not attempting to add anything. I am giving evidence. And in my view, it is because of the chapeau 3.1, what I'm saying is admissible and should be considered, because these subparagraphs, if you want to call it that, 3.1.125, are not limited. And so I'm giving evidence about what I know and what I've experienced, and that's all I can do here.
Advocate Batohi, you are still not answering my question. The question is straightforward. That charge, I know the word charge is a strong word, but it was introduced, thankfully for all of us, by the chair, refers to the finalization of the answering affidavit. Doesn't refer to these other steps you are talking about.
But it includes them.
Where does 3.1.1.3 include them?
I said the chapeau includes them.
Yes. So the preamble,
Yes, 3.1.
yes. Now, we are still to look at what the draft was. Because it seems to me that the simplest thing would have been to tell Mr. Chauke that you are accused of preparing the answering affidavit. You are also accused of the following preparatory steps, because that is all information that was within your knowledge when these charges were prepared. Is that not correct?
It was within my knowledge, that's correct.
Yes. And now, why don't you include it in 3.1.1.3?
If we wanted to include everything, we would have had to include Dr. Broughton's bundle as the charge sheet, because it has lots of conduct of Advocate Chauke that would fit into some of these, like his role in preparing the answering affidavit.
But Advocate Batohi, I'm asking you about one aspect. I've not even come close to Dr. Broughton. I'm asking you about the preparatory steps that you have sought to add to 3.1.1.3. Why were they not reflected? It would have been one sentence in 3.1.1.3.
I can't answer why it was not included, but that's
Yes.
my evidence.
Thank you very much. Then I said to you that there was a further aspect of this charge when in my analysis I couldn't understand. It talks at the end, in the last line, with racketeering charges against the accused. Now, on the one hand, it may appear to refer to all of the accused. And on the other, it may appear to refer only to Major General Boyson. Does it refer to Major General Boyson only, or does it refer to all of the accused?
I'm looking at the context of this charge, and well, for want of a better word, and the way it's framed in order to answer your question. It says here, he finalized the answering affidavit of the then acting NDPP Advocate Jiba in the Boyson review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, given that it is referring to the Boyson review application, my interpretation of that would be that it refers to Boyson alone.
All right. So unlike 3.1.1.1, which you said refers to all of the accused, 3.1.1.1.3 refers only to Major General Boyson.
Yes, that is correct.
Yes. And can you explain why it did not say against Major General Boyson?
I can't.
Because that again would have been a very simple insertion. You would accept that?
To the extent that it's relevant, it would be a simple insertion. But
Well-
it doesn't make a difference to what's said there.
Well, okay, let's talk about the relevance. It's clearly relevant to tell Mr. Advocate Chauke what the scope of the allegation is. And if the scope is limited to Major General Boyson, it's relevant to tell him that. Wouldn't you accept that?
Well, in this context, it is telling him that.
Yes. Now, if you look at 3.1.1.4,
Marcel, before you go there, and Advocate Batohi, this is just a clarity-seeking exercise on my part. whilst we are still on 3.1.1.3, look at paragraph 142 of your affidavit. It's on page 60.
Mhm.
This paragraph refers to the unlawful action on the part of Advocate Chauke as the de facto DPP. You remember?
Mhm. I do.
That was your evidence. And now, when we unpack this allegation or this statement on your part relating to the unlawfulness or the alleged unlawfulness on his part, I suppose we should then go to the terms of reference 3.1.1.3 that we've just been talking about, and try to relate it to what you allege to be an unlawful action on his part. If one were to look at 3.1.1.3 regarding his having finalized or settled the answering affidavit on behalf of Advocate Jiva to defend the review application, will that per se constitute an unlawful action? Put differently, will the mere settling of an affidavit on behalf of the head of the NPA in itself constitute an unlawful action? Because what I seek to understand is precisely what is this unlawfulness that you are referring to. Is my question clear to you?
Reasonably, Chairperson.
I beg your pardon?
Reasonably clear. I will try to answer it. Chairperson, the unlawfulness of Advocate Chauke's conduct is all actions he took in the context of this matter, particularly relating to prosecutorial decisions as the de facto DPP in this matter. Those actions that he would have taken in that context would be unlawful. This particular act of finalizing an affidavit, generally, it would not be, in fact, DPPs would be involved in such actions for a national director to settle affidavits. But if in the settling of the affidavit, you are actually taking a prosecutorial decision to appeal a matter or to recommend to the NDPP that this matter be appealed on the basis of the contents, or not appealed, the matter be opposed on the basis of what is contained in the answering affidavit, then in my view, that amounts to his role as the de facto DPP and would in fact also be something that a decision a prosecutor would take in terms of opposing an application. And in that sense, it would be unlawful conduct.
It's kind of a long answer, but I just want to ascertain from you whether that single act in relation to 3.1.3 of the terms of reference specifically reflected as, I quote, he finalized the answering affidavit of the then acting national director of the public prosecution's advocate Nomgcobo Jiba in the Boyson's review proceedings. It is that act just to focus on. Understand whether the allegation of unlawfulness in your affidavit at paragraph 142 covers that limited aspect of the terms of reference that I have just read to you. Let's not talk about anything else because I assume they will deal with further decision. I just want to clarify in my mind whether this act of settling an answering affidavit on behalf of the head of the NPA in itself constitute an unlawful action.
Chairperson, my answer to that is yes, it does, for the following reason, that a decision to oppose a review application is a prosecutorial decision. And that decision to oppose was taken by Advocate Chauke and supported by him as reflected in the contents of the affidavit that he settled.
And that affidavit that he settled is not his affidavit. It is under the signature of the head of the NPA.
That's correct.
Who will take the rap for whatever is in that affidavit, irrespective of who settled it?
That's correct.
Am I correct?
Well, that's correct. She will take the rap for it to the extent that, there's anything unlawful about that. If there is.
No. I just want to ascertain from you as to, even if somebody drafts something for you as the head of the NPA and you append your signature ultimately on that very document, it is you who's going to be accountable for whatever appears in the document that you sign.
Yes, Chairperson, to the extent with regard to the conduct of the signatory to an affidavit, you will be, but here we're looking at the conduct of Advocate Chauke before that in taking a prosecutorial decision.
I'm not asking about that, Counsel. I'm just talking about a simple thing in relation to signature.
Mm-hmm.
And the impact of your signature on a document, irrespective of who drafted it, that you'll finally apply your mind to the content of the document and decide if you align yourself with its content. That's what I'm trying to ascertain with you. That finally, irrespective of who proposed, who advised, who drafted it, you are the final decision maker in relation to the contents of this very document. That's what I'm just trying to ascertain.
That's correct, Chairperson.
Yes, thank you.
Thank you, Chair. Advocate Batohi, I am still on 3.1.1.4.